Every day, police officers pull somebody over while they're driving down the road, and the police officer approaches that car and says, do you know how fast you were going? And the person may say, well, I think I was going 55. Police officer says, no, you were going 80. The question that I have for you is, did a felony just occur? And the answer is yes. You see, under Title 18, Section 1001, it is a federal crime anytime somebody tells a lie to a law enforcement officer. Person doesn't have to communicate with the law. A person at any time can say, I take the Fifth Amendment and not provide information. But if somebody does talk to a law enforcement officer, they'd better tell the truth, because if they don't, they're exposing themselves to new criminal conduct. My name is Michael Santos, and I'm with Prison Professors. We work together with an entire team of people who have gone through government investigations and who have faced challenges from the law and have paid the price. That's the reason we produce so much content, with hopes of helping more people avoid these complications that can completely derail prospects for happiness and fulfillment, at least until you get to the other side of this journey of turmoil and so on. Well, today I am going to be reading an article for our podcast and also for those who visit our website, but you may be watching this on YouTube because people try to get content in all types of ways, and we want to provide that content in every way possible to make it easiest for consumers to learn more about how they can avoid altercations or challenges with the criminal justice system, or they can make decisions that will just completely keep them out of the crosshairs. But God forbid, if they are brought into a crime or a charge, we want to make sure that we're giving them as much information as they can, with hopes of helping them make better decisions. You see, there are real ancillary consequences that follow and collateral consequences that follow for anybody that's brought into the criminal justice system. We want to help people get better outcomes. And so I want to take the time to read this article that one of our team members wrote specifically for our website. So it's about perjury and making false statements, describing how they're serious federal felonies carrying up to 5 years in federal prison. Introduction. Before testifying under oath in any proceeding or filing papers with government authorities, it is essential to understand the crimes of perjury and making false statements and their potential consequences. Perjury, under Title 18 U.S. Code Section 1621, can occur in many settings. It is more than lying under oath while testifying in court. It also includes lying at congressional hearings or in depositions in civil lawsuits. Sworn statements made to governmental agencies like the Internal Revenue Service or in financial affidavits, such as loan applications and tax filings, are also covered. Now, I have personal experience with that because when I went to trial back in 1987, I took the stand in my trial. And that means I put my hand on the Bible and I said, I swore to tell the truth, so help me God. And then I proceeded to lie in my testimony, saying that I wasn't involved in this crime and so on and so forth. And of course, that really contributed to me getting a longer sentence, but also being charged with new criminal conduct under perjury. And it's something that people need to be thinking about, because a lot of times we have a natural inclination to minimize our misconduct or to try and persuade people to see things from our perspective. But if we're lying, and particularly if it involves a criminal proceeding, we could really exacerbate our problems and expose ourselves to much more difficult sanctions. Let me continue with the article. Suborning perjury applies when a person induces or causes another person to commit perjury. So that's another federal crime. A closely related crime is making false statements. That was when I opened up with Title 18 U.S.C. Code 1001. Title 18 U.S.C. 1001 makes it a crime to knowingly and willfully make any material false, fictitious, or fraudulent statements from representation in any matter within the jurisdiction of the executive, legislative, or judicial branch of the United States. So the language of Section 1001 is very broad and applies in cases where a false statement does not meet all the requirements necessary for perjury. For example, perjury covers statements under oath, But when a witness's false statement was not under oath, 18 U.S.C. Section 1001 for making false statements to government agents may still apply. That means if you're filling out a mortgage application, or if you're communicating with somebody in some kind of manner that can influence somebody to do something on false pretenses, a person can be charged. In criminal cases, government investigators often talk to witnesses while out in the field. Lying to investigators during such a witness interview may not constitute perjury, but it can still be punishable as a crime for making a false statement. This is especially important for people who are involved in government investigations. Like in any investigation, perjury and false statement cases present a range of potential outcomes. Sometimes it may be possible to avoid formal criminal charges or prison altogether. Our team at Prison Professors works alongside criminal defense attorneys, and we also work with individuals who just reach out to us because we really want to help them understand, hey, work toward a better outcome. But you don't have to pay us for that. Just watch these videos or read all of the content that we provide, and this is kind of the way that we strive to be the change that we want to see in the world. Remember to always speak with criminal defense attorneys for legal advice regarding any court case. Now, what's the difference between perjury and making false statements? Perjury requires a knowingly false statement under oath that is material or relevant to the matter at hand. Just remaining silent or refusing to provide any statement at all, so-called lies of omission, do not constitute perjury. And for perjury, the statement must be literally false and made with the intent to deceive or mislead. In contrast, making false statements applies when people lie to the government, regardless of whether it's under oath. The false statement law is so broad that it can apply to almost any interaction people have with government agents and agencies. Again, including driving down the road and saying you didn't speed. In the highly publicized case of business mogul Martha Stewart, Stewart was convicted and sent to prison for making false statements to federal investigators, not perjury or insider trading. Stewart lied about receiving and acting upon inside information while she was in the midst of a government investigation. Michael Cohen, former President Trump's longtime personal attorney, also faced a sentencing for lying to Congress. Cohen pleaded guilty to a single count of making false statements to the Senate Intelligence Committee during a closed-door meeting. Both perjury and making false statements are process offenses since they interfere with the administration of justice and undermine the integrity of the process. Federal and state penalties. Perjury and making false statements are felonies at both the federal and the state levels. A person convicted of perjury under federal law may face up to 5 years in prison. Perjury also carries fines and probation, depending upon the context and the severity of the crime. Potential federal penalties for suborning perjury or making false statements are similar. The punishment for perjury or other similar offenses under state law varies from state to state. But still, it is a felony and carries a possible prison sentence of at least 1 year, plus fines and probation. And that can bring many collateral consequences as we write about so frequently in our content. Sentencing judges may increase the penalties in perjury cases depending on the conduct's role in the proceedings. For example, when a witness in his own criminal trial commits perjury, the judge may enhance the sentence on the underlying conviction. It is also important to note that federal judges will not hesitate to refer witnesses to the Department of Justice for prosecution when they lie in court proceedings. The DOJ generally complies. Now, is perjury hard to prove? Well, in review, the crime of perjury occurs when someone under oath, knowingly and with intent to mislead, makes a false statement during a court case or other legal proceeding. The false statement must be material to the subject matter of the proceeding. Put differently, a conviction for perjury requires that prosecutors establish a knowingly false, material statement under oath made with intent to mislead. The general consensus is that perjury is difficult to prove. A prosecutor has to show that there was a material misstatement of fact under oath and that it was so willful that the person knew it was false when they said it. To achieve that, a prosecutor must present evidence that contradicts a witness's sworn statement and proves the witness's intent to deceive or mislead. In defense, the accused will attempt to show any of the following: that mere silence or refusal to speak is not enough, that the false statement was not under oath, that the witness did not know the statement was false, that the witness did not intend to mislead, that the statement was factually true, that the statement was the result of confusion, memory lapse, or mistake, that the statement had no relevance or bearing on the proceedings, in other words, it was not material, and that the statement was later corrected or recanted. Now, recanting or correcting a false statement. In a federal case, a witness can argue that the correction or retraction shows a lack of intent to mislead. Recanting, retracting, or correcting prior statements are not, in and of themselves, legal defenses to perjury charges. Whether such a defense is viable in state perjury cases depends on state law. Now, in some perjury and false statement cases, recanting or correcting false statements while the case is still pending can help mitigate potential consequences. All legal defenses and mitigation strategies are really matters for a person to discuss with a defense attorney. We're only people who've gone through the system, and we share what we learned. I know that I made so many bad decisions as a young man that all of that contributed to me getting a much longer sentence. And that's why we want to help people understand there are real consequences that follow coming into the crosshairs of a government investigation, but there's always a way through, and there's always a way to work toward mitigating. It's never too early, and it's never too late to start making better decisions, and that's what our team really encourages people to do. So in conclusion, perjury and making false statements are serious federal felonies carrying up to 5 years in prison for each count of the lie. I got 2 counts of perjury, as I recall, when the authorities brought the case against me. But these crimes also fall under jurisdiction of state jurisdictions. Remember, in the United States, we have 53 different criminal justice systems. The military system, every state, all 50 states have a criminal justice system. The District of Columbia has its own codes of statute and laws, and of course, then there's the federal system. So before testifying under oath in any proceeding or filing papers with any government authorities, make sure that you understand the crime of perjury, and also make sure that you understand the crime of Title 18, 1001, making false statements. We don't want anybody going into the system that shouldn't be going into the system. And the only way we can do that is by repeatedly creating content to help spread more awareness to the collateral consequences that follow big government and big investigations. If you don't think it can apply to you, really do some research and see how easily a person can be brought into really drastic proceedings and draconian sentences, because that's the way our system operates. And our job is to try and help people make better decisions, hopefully avoid problems in the first place, but if they come inside, we want to help people get the best possible outcome. That's what we do at Prison Professors, and we encourage you to consume our free content by becoming a part of our newsletter. Just by visiting our website, we'll send you some free books and some free information, or subscribe to us on our YouTube channel at Prison Professors or on our podcast as well. My name is Michael Santos. On behalf of our entire team, we thank you for being a member of the Prison Professors community.